Hello everyone, welcome to IMS Get Set Law channel. I'm Akash, Srivastava, your law mentor, and today in Law Library session I'm going to discuss a very important judgment. The name of the judgment is Lalman Shukla versus Gauri Dutt. So students, before we discuss what exactly happened in this case, then relevant provisions and judgment, it is very important to understand why this case is important for us, for all the law aspirants and also for the students who are studying law in the law school. So in this case, court clarified whether the knowledge of proposal is a mandatory condition to a contract or not. So students, if you are aware about contract law, you may be very much sure what proposal is, or all the law students who are studying in law school, they must be aware what a proposal is. But for a layman who have never heard about contract law, have never read about contract law, it becomes very important to understand what proposal is, because this is not a layman term. So when we talk about contract, the process starts from here. So for example, if I want to sell my laptop to my friend, I will make an offer to him that, dear friend, I want to sell this laptop for 50,000 rupees. Are you willing to buy it? So this statement of mine will be termed as proposal, and from this statement, the process of contract starts. So students, this case clarified whether the knowledge of proposal or the knowledge of the offer is a mandatory condition to a contract or not. So if we talk about a contract, whether what I'm offering to my friend, whether the knowledge of that offer to my friend is mandatory condition or not. So for example, if I'm saying that I want to sell this laptop to my friend for 50,000 rupees, whether this statement of mine, so whether the knowledge of this statement to my friend is mandatory condition for a contract or not. So students, let's discuss the facts of the case. There are two parties in this case. The first party is Lalman Shukla, that is the appellant, that is filing a case against Mr. Gauri Dutt. So what happened? So Mr. Gauri Dutt's nephew had absconded from his home at Kanpur, for which he sent out his servants in search of him. So he sent his servant in search of his nephew, and also along with servants, he sent his Munib, accountant of the firm, was also sent to Haridwar for the same purpose and was handed some money by the defendant for his railway fare and other expenses. So after sending his servant and accountant, defendant announced a reward of rupees 501 for whosoever found his missing nephew. So if anyone found his missing nephew, he is willing to pay 501 rupees as a reward to him. However, unaware of such an announcement, the plaintiff finds and brings the missing nephew back home to Kanpur. The defendant, that is Mr. Gauri Dutt, rewards him 20 rupees. So initially what happened, he sent his servant as well as Munib in search of his nephew. After sending servants and Munib, he announced a reward of 501 rupees. But after Munib brought the nephew back, he gave him 20 rupees only. So 6 months after the incident, the defendant fired the plaintiff from his job. That is, Gauri Dutt fired Lalman Shukla. After being removed from the position, the plaintiff, that is Lalman Shukla, claimed the money from the defendant and the later denied paying the said remuneration. So he asked for 501 rupees because he was only given 20 rupees. So he asked for that remuneration but was denied by Gauri Dutt. As a result, Lalman Shukla filed a case against Gauri Dutt at the Court of Small Causes at Kanpur. So students, I will summarize the facts. So what happened? There was a person named Gauri Dutt whose nephew was missing. So he sent his Munib as well as servant in search of him. And Munib, and meanwhile, he announced a reward of 501 rupees. But Munib was not aware about this reward and brought back the nephew. But Lalman Shukla was only given 20 rupees from Gauri Dutt. But after a few months down the line, he was fired and asked for that amount of money but was denied. That's why he's filing a case against Gauri Dutt for that amount. So student, before we start discussing what court decided in this case, it is very important to understand what were the relevant provision in this case. So there are three relevant provisions. The first one is Section 2A of Indian Contract Act, Section 2B of Indian Contract Act, and Section 2H of Indian Contract Act. So Section 2A of the Indian Contract Act defines proposal. So I've already explained what proposal is, or in layman terms what an offer is. So if I'm saying that I want to sell my laptop to my friend for 20,000 rupees and I'm asking to my friend, I'm willing to sell this laptop for 20,000 rupees, are you willing to buy it? This statement will be termed as offer. So they have written, say, when one person signifies to another his willingness to do or abstain from doing anything. So I'm willing to sell my laptop. Why I'm willing to sell my laptop? With a view to obtaining the assent of that other, because I want the other person should agree on this and give me 20,000 rupees. So this statement will be known as proposal. The second definition is Section 2B, that is promise. When the person to whom the proposal is made, so I said that I am willing to sell my laptop to my friend. So I asked him, I am willing to sell this laptop for 20,000 rupees. Are you willing to buy it? If the other person agrees to it, then that will be known as acceptance, and the whole process will be known as promise, that is defined under Section 2B of the Indian Contract Act. And the last definition is section 2H, that defines contract. It is saying that an agreement enforceable by law is a contract. So students, it is very important to understand the process of contract. First of all, there will be an offer or proposal and the other party needs to accept it. So offer plus acceptance will be termed as promise. If we add consideration to promise, then it will be termed as agreement. So what will be a consideration? What exactly a party is getting from that contract. So for me, the consideration will be 20,000 rupees, because in this contract, I'm getting 20,000 rupees, and consideration for my friend will be this laptop. So offer plus acceptance is promise. If we add consideration to promise, then that will be termed as agreement. And if we talk about section 2H of the Indian Contract Act, it is saying that an agreement enforceable by law is a contract. So if this agreement can be enforced by any of the parties in court of law, then this type of agreement will be termed as contract. So these were the three definitions used in this case. So students, now let's discuss the judgment. So what happened in this case? The court held that the basic necessity for a contract is, first of all, knowledge and the assent of the proposal to convert a proposal into an enforceable agreement. First of all, if I'm making a proposal, if I'm making an offer to another person, the knowledge of that offer to the other person is very important. So as I said that I'm willing to sell this laptop for 20,000 rupees. If I'm making this an offer to my friend, the knowledge of this offer to the other person is very important. That is the first part. And the second part is the other party needs to agree to this particular offer. Further, it was observed that there was no acceptance of the offer. So if I'm making an offer, the other party is not accepting the offer. So there was no agreement to be enforceable by law in the present case. As I explained the process of contract, whatever offer I'm making, the other party needs to accept that offer. As the plaintiff was not even aware of the reward announcement, so he cannot accept that offer by the plaintiff. So the two essential elements of a contract needed to be considered in the present case are: the first, complete knowledge of the facts of the offer or proposal. So whatever the person is offering, whatever in this case Gauri Dutt offered, it needs to be conveyed to the other person, and the other person needs to be aware, that is Lalman Shukla should be aware of this offer. And the second part is acceptance of the offer. So after having the knowledge of the offer, the other party needs to accept this offer. Since both the elements were missing as per the definition clause of the Indian Contract Act, according to court, both these things were missing in this case. To make the contract enforceable by law, the court dismissed the appeal made by Lalman Shukla against Gauri Dutt. So court disagreed with Lalman Shukla that you should be getting a reward. So the court decided that here the plaintiff only fulfilled his duties as a servant to his master. He only did that act as a servant and should not be rewarded. Therefore, Lalman Shukla, plaintiff, was not entitled to get the reward money for searching for Gauri Dutt's missing nephew. So students, this was all with respect to today's case. So I will summarize the case for you. So what happened? There was a person whose nephew had absconded from his home. He sent his accountant in search of him. While he sent his accountant, he announced a reward of rupees 501 to anyone who finds his nephew. But this was not known to the person, not known to the Munib, and he brought back the nephew and was rewarded 20 rupees only instead of 501. He filed a case 6 months down the line. He files a case for that 501 rupees. So it was decided by the court, if we talk about a contract, because this is a contract, you need to be aware about the offer. If you're not aware of the offer, then you cannot enforce the contract. So this was all. I hope you enjoyed the video. Stay tuned for many more videos like this. Thank you for watching.